Good morning. I'm Gary DeWaal, and this is Bridging the Weeks for February 12th to 23rd, and today is February 26, 2018. The United States Supreme Court made it clear that to receive the benefits of the anti-retaliation provisions of the Dodd-Frank Wall Street Reform and Consumer Protection Act, a whistleblower must first identify potential security law violations to the Securities and Exchange Commission and not with his or her employer. This is not a good outcome for business. Separately, a bank was sanctioned over $600 million by 4 federal regulators for not employing a sufficient number of anti-money laundering personnel and capping the number of exception reports generated by its AML surveillance system to accommodate the reduced number of AML employees. Spring training began last week in the United States, signaling the imminent end of winter. So I can settle in and watch some baseball games to distract me from bad New York sports teams playing basketball and hockey. Let's get started. The United States Supreme Court held that whistleblowers reporting potential securities law violations must first report such incidents to the Securities and Exchange Commission in order to benefit from anti-retaliation provisions and a potential reward from the SEC under the 2010 Dodd-Frank Wall Street Reform and Consumer Protection Act. Among these provisions is the right of a whistleblower claiming retaliation to sue an employer directly in a federal court at any time within 6 years. This is different from the anti-retaliation protections under the Sarbanes-Oxley law previously adopted in 2002, which applies to all employees who report misconduct to the SEC, any other federal agency, Congress, or an internal supervisor. Under Sarbanes-Oxley, a whistleblower must, within 180 days of alleged retaliatory action, file a complaint with the Secretary of Labor, and only if the Secretary has not issued a final decision within 180 days, and then only under certain conditions, may a claimant file a lawsuit in a federal court. The Supreme Court ruled that the plain language of Dodd-Frank restricts its anti-retaliation benefits to whistleblowers that provide information, quote, to the Commission, end of quote. This decision is not a favorable outcome for companies. An analysis of this decision is at the article version of this blog at www.bridgingtheweek.com. Check it out. 4 federal regulators imposed out-of-pocket sanctions on U.S. Bancorp totaling $613 million for alleged noncompliance with its anti-money laundering obligations from 2011 to 2015. The regulators were the U.S. Department of Justice, the Board of Governors of the Federal Reserve System, the Office of the Comptroller of the Currency, and the Financial Crimes Enforcement Network of the U.S. Department of Treasury. The regulators claimed that, during the relevant time, the bank failed to maintain an adequate staff level to conduct AML oversight and to accommodate an inadequately sized staff, capped the number of alerts generated by its AML surveillance system. This, alleged the regulators, caused the bank not to identify many potential AML issues and not to make many required suspicious activity reports. The bank also took affirmative steps to cover up its deficiencies and mislead the OCC, claimed the OCC. The bank purportedly also filed incomplete currency transaction reports to FinCEN during the relevant time. These reports identify currency transactions that involved or aggregate in excess of $10,000 a day. In aggregate, the bank was assessed sanctions totaling $803 million, but both FinCEN and the Department of Justice gave some credit to payments made to other regulators. It may seem like a cost saving to skimp on AML and compliance staff, but in the long run, it's not. And finally, the Securities and Exchange Commission filed a civil action in a federal court in New York City against Bitfunder, an alleged non-SEC registered securities exchange that traded shares in virtual currency-related businesses, and John Montrol, the founder and developer of Bitfunder, for operating an unlicensed security exchange and engaging in fraud. Separately, Mr. Montrol was criminally charged by the U.S. Department of Justice with lying to the SEC during sworn testimony and obstructing justice. According to the SEC, from December 2012 through November 2013, Mr. Montrol misappropriated customers' Bitcoin, lied about a hack of the Bitfunder ecosystem in the summer of 2013 that resulted in a loss of 6,000 Bitcoin and raised funds for shares of a specific security, UKYO.loan, and misappropriated funds from these investments too. The Department of Justice claimed that Mr. Montrol lied about the Hackabit funder to the SEC during its investigation. The SEC seeks an injunction against the defendants, disgorgements, and fines. In connection with his criminal charges, Mr. Montrol, if convicted, faces imprisonment for up to 20 years. As I indicated a few weeks ago, the SEC takes a very broad view of what constitutes a security, and this has caused confusion regarding when a cryptocurrency may fall under the SEC's jurisdiction. 2 weeks ago, the Swiss Financial Market Supervisory Authority endeavored to provide some clarity regarding its own oversight of different types of digital tokens, which it described as payment tokens, utility tokens, and asset tokens. It's a good starting point, but flawed. I have a full analysis on this on the article version of Bridging the Week at www.bridgingtheweek.com. Check it out. Well, that's it for this week's edition of Bridging the Weeks. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. By the way, that's www.bridgingtheweek.com. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.